This is Mid-Atlantic Women in Agriculture's Wednesday webinar, Land Titles. Our presenter today is Paul Geringer, Research Associate and Extension Legal Specialist with the University of Maryland. All archived presentations, along with all upcoming presentations, can be found at our website, and a special thank you to our sponsor. Since this is an archived presentation, all questions can be directed to Paul with the email address provided, and all materials mentioned through the webinar can be found at our website. Thanks so much for listening.
So the importance behind land titles is it comes down to is not only with land titles, but with any type of property you're going to own, it comes down to is who owns it, how do you own it, and what can you do with it. And before I get started, I have to give my normal disclaimer. None of this is legal advice, yada, 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 yada. And part of my funding for my project comes from the University of Maryland Empower. This is an institution or a group that partners University of Maryland College Park with the University of Maryland Baltimore to sort of focus on issues together. So with this, we're focusing with the law school on ag law issues. And as a part of this, we also bring in, which is kind of unique for an Empower project, we bring in UMES as a part of it. So we have people at UMES, College Park, and at the law school in Baltimore soon. And you can see our website there. We're on Twitter, Facebook. You can email us there too. And before I get started, I have to give a thank you because I stole part of this from an original presentation that Lori Lynch had done over time over the same topic. So many of the slides you're going to see are what Lori has done in the past. And if you don't like listening to me or you want to read this to help me kind of put all this together, if you look over to the right in the web links, the top one will take you to a little post to help you better understand this topic. So if you forget something, it's up there too. And I think this is being recorded, so you can also go back and view it at any time. And also up there, I put a link to the estate planning fact sheet because this is land titling is an important part of estate planning. And now I think we're ready to actually start the webinar. So sort of to give an overview, this with land titling or any titling of any property, it's going to come down to what type of property it is to start with. So we need to kind of give a basic overview of what property is. So we have two types of property. We have real property and personal property. And real property is defined as land or anything growing on, attached to, or erected on it, excluding anything that may be severed without injury to the land. So my example is farmland. I have growing crops in there. Growing crops would not be an example of real property. I don't know what I was thinking when I put that together. It would be an example of personal property. But a barn, a house, anything structure like that that's going to be on your land is going to be an example of real property. And personal property is pretty easy. It's basically anything that's not classified as real property, but the technical legal definition is any movable, intangible thing that is subject to ownership and not classified as real property. So example would be harvested crops, tractor, livestock, any type of farm equipment, etc. So why is ownership going to be important? So how many of you have actually looked at your property deeds? That's going to tell you a lot of how this property is owned, and it's going to tell you your rights in the property as we go along. So as you do this, I would encourage you to go back and look at deeds. You may see that you own property in certain ways that you may not. But as I say, too, I kind of talk in terms of real property, but personal property can be owned in any of the ways we're going to talk about. So you may look back and own farm equipment or something like that in a similar type of ownership situations that we're going to discuss here coming up. Another reason why it's important is estate planning issues are going to have a lot to do with this. So the goal of your estate plan is sort of to fulfill whatever the goals are you have for your property at your death. A will is just one way to achieve this. Titling a property in certain ways may also achieve this for you. So we may be able to title property in ways, as we're going to discuss, that would allow it to bypass the probate system and get it in the hands of the person that needs it quicker. So if you're in business together with a child, a sibling, any other family member, or just anyone in particular, and you want equipment from the company to go on to that person, it may be quicker to title it in certain ways so it bypasses the probate process and that person is able to utilize it a little more quickly. It's a little bit more of an efficient way than utilizing a will. So as we start looking at the forms of property ownership, and we're going to talk about each one of these individually as we go along, but I'm just going to kind of give you an idea of what we're going to talk about. We're going to talk about sort of fee simple, ownership in property, what is a life estate, and then look at tenancy in commons, joint tenancies, which is also sometimes called joint tenancy with rights of survivorship, and then tenancy by the entirety. So to start with, we'll look at individual ownership, and this is basically you own the property by yourself. No one else owns it with you. So there's only one form of this. It's fee simple. Fee simple is the highest form of property ownership. It's sometimes called fee simple absolute. Just depending on who's writing it will depend on how it's written. But with this, you can basically give it away. You can sell it. You can divide it. You can make all the decisions that go into it. You're the only owner in the property, so you are able to make all those decisions. You receive all the income off that property. If there's interest accruing on that property in some way, so if it's a bank account, you would be entitled to all the interest. You can pass it on to your children, or you may just decide that you don't want to pass it on to your children for whatever reason, so you can do that. But you're also liable for all obligations on that property. So if you take a mortgage out on the property, you may be liable for that mortgage if it's not paid. You would have to pay property taxes on it. And these obligations pass with the land if the land is used as collateral for a loan. So, like I said, it's owned by one person, and really the only limitation on your rights are any governmental restrictions. So property taxes would be one. Potentially the government may want to do an eminent domain, take part of the property for some project. They may put reasonable regulations in place that would restrict the property. And this next one I'm calling, it's not exactly ownership of the property, but it's close. You hold an interest in the property, and the idea would be with a life estate. So you don't exactly own the property, but you're a holder of an interest in it during your lifetime. So while you're holding that interest, you're called a life tenant. You're not really the owner, but you still get to make a lot of the decisions that go on the property. So the owner owns the property for your lifetime, but upon your death, it's automatically chosen who it goes to. So you do not get the ability to say who the property goes to. It automatically is deeded to someone. This may be a parent who doesn't trust a child after their death, so they decide to leave a farm to them as a life, the child as a life tenant. And then upon that child's death, the parent may have already decided who is going to take over that property. So it may be another one of their siblings or maybe a grandchild. It just sort of depends on how that is set up. But a life tenant can exclude others from the property, even the one who will receive the property once the owner dies, or once the life tenant dies. During your lifetime, you collect all the income and interest in the it can be leased, but cannot pass on to children. It's difficult to sell because the ownership rights more or less are tied to your life, and no one really knows how long you're going to live. So it would be difficult to put a value on that piece of property. cannot use for collateral for a loan in many cases for the same reason, because we don't know what the tenant's life expectancy is, so they may die before the loan is able to pay off, and the interest in that collateral would disappear. There is issues with economic waste on the property, so if the income from the property less the expenses for taxes and interest on the mortgage, courts may force a sale in those cases. And at any point, if you have a question, please type them in the box. I'm trying to keep my eye on it. The next issues are going to be a lot, or next property ownership is going to be a lot with co-interest. So we've looked at what one person can own the property as. The rest of these require at least 2 or more people involved in the ownership of that property. So each co-owner will have the right to access the property. They can demand an accounting of profits, which is legal terminology basically for if one of the co-owners has been receiving all the rent money or has been on the property utilizing it in some way as a part of a farming operation, some sort of business in any way, or made improvements to the property, you can demand as a co-owner the right to see, one, how much lease money they've been paid. You may be able to demand an accounting to see what type of improvements they made to the property, if they've made any at all. And at the same time, you're going to be required to contribute to the cost of the property. So if there's property taxes on the property, you have to pay your share of the property taxes. You may have to pay your percentage for the cost of improvements to the property. And that's going to depend on sometimes what the parties agree to, each co-owner agrees to. So the important thing to remember about this, and you're going to see this as we go along, all forms of co-ownership are not equal. Each is going to have a rationale as to why we would utilize it. It's going to depend on what goals are and other things that are going to go into this decision-making process. But the typical forms of co-ownership that we're going to talk about today are tenancy in common, joint tenancy, and then tenancy by the entirety. So tenancy in common requires 2 or more owners, and these are going to be called tenants in common, and each owns an undivided interest in the property. Although they hold an undivided interest, they could have unequal rights in the property. So, for example, Stacy and Sarah are tenants in common to Blackacre. Stacy owns 60% and Sarah owns the remaining 40%. So the idea is we may not be able to divide up exactly who has 60% and which 60% is actually Stacy's and which 40% is actually Sarah's. That's where the undivided interest comes from, but they own a different share of the property. So they can convey their interest in land either by sale or by inheritance. So Stacy can pass on her 60% of the property either if she decides to sell it or she dies, she can leave it in her will. They can each mortgage their own interest to secure a loan. However, you can't sell the other owner's interest. You can only sell that one co-owner's interest in that property. The big thing with tenancy in common, and we're going to talk about rights of survivorship here, and that basically the idea with rights of survivorship is that if one of the co-owners passes away, their interest goes to the remaining co-owners. So here with tenancy in common, there is no right of survivorship. If Stacy predeceases Sarah, then Stacy's interest would pass under the terms of Stacy's will or under state intestacy's law, which if you need to know what any of that means, that's why that estate planning fact sheet is up there. In other forms of co-ownership that we're going to talk about do have a right to survivorship included in them, which is one reason why some people pick them and they're a useful estate planning tool. Tenancy in common typically may not have all the benefits of a good estate planning tool because there is no right to survivorship. And if you want to know the language to look for in a deed or any other document, it's simply to A and B, to whatever the parties' names are. The idea there is we're going to talk about with the language to create the other forms of co-ownership. If you had wanted to utilize a better form of co-ownership, you would have used it in the document creating the interest. So next, looking at joint tenancy, the holder of a joint tenancy is called a joint tenant. Each joint tenant will hold an undivided and equal interest in the property. We don't really care how much each one contributed to the cost of the property. They're each going to hold an equal interest. So if there are two parties, they're going to own 50% each. Three parties would be about 33%, so on and so on. So as we add co-tenants on, it's just an equal interest out of that 100%. And the big thing with joint tenancy is each joint tenant has the right of survivorship. The right of survivorship allows a surviving joint tenant to claim the predeceasing joint tenant's interest in the property. And the basic idea is why the survivor picture is up there is the last person left standing or alive at the end inherits the property in fee simple. They're the only owner of the property. The joint tenancy is gone. They now own it in fee simple, and they can will it on to whoever they want to or sell it to whoever they want to. To create a joint tenancy, these are a little unique to create. You need 4 unities. We need unity in time, so you must acquire the property at the same time. You must have the same title to the property. You must have an equal interest in the property, and you must all own an equal right to possess the property as a whole. Typically, if you own a piece of property and you want to put it into a joint tenancy, so you own it by yourself, but you want to put it in joint tenancy with another party, the idea here is we would effectively pass the property on to some sort of third party, and then they would deed it back to the two of you to effectively create these 4 unities at once. There are other ways around that, but that's one common way. The reasons a lot of people look at this is it's just one way to avoid cost and time involved in the probate process. So if you have some sort of equipment property, you either want a spouse or a business partner, a sibling, a child to be able to utilize more quickly than going through the probate process. This would be one way to do it. It saves a lot of the cost involved there. One thing to point out on these, you can sell your share of the property, but again, that destroys the 4 unities. So if you sells the interest before death, it severs the survivorship right for the new owner. So the remaining joint tenants would continue to be joint tenants with each other, and the new co-owner would be a tenant in common with the joint tenants. If we only have 2 joint tenants and one decides to leave the joint tenancy, the new owner and the remaining joint tenant would just become tenancies in common. And looking at this, a joint tenancy, if you're looking at the type of language that's used to create it in the document, it's usually to A and B as joint tenants with rights of survivorship and not tenants in common. So you can see there it's a little more clear as to what you're creating than previously with tenancy in common, because we're being very specific that this is the type of interest we're creating. If it's not clear that that's what you're creating, so if you typically, if you would just put 2A or B, you're going to create a tenancy in common. If you didn't put in there that you were creating the joint tenancy, it's probably going to revert back to a tenancy in common, but that's going to depend typically on if there is an issue, how a court decides that, and what previous court decisions have been on this issue. I think there was one last thing I wanted to say on that, but I can't remember what it was. So since I can't remember, we'll go on to tenancy by the entirety. So this is similar to a joint tenancy in that the tenants have rights of survivorship, own equal and undivided interest. It's not recognized by all states. I have it here. It's recognized by Maryland. If anyone's in Delaware or Virginia, it's also recognized in those states as well. It can only be created by a married couple. And all property owned by the married, and typically all property owned by a married couple is presumed to be tenancy by the entirety. The way around that assumption would be putting in the deed, putting in the document language such as we saw with joint tenancy, that you're creating a joint tenancy with rights of survivorship, not tenancy in common, or you could put in there that you wanted to create a tenancy in common with the parties. It's all just sort of how you decide it needs to work out for you. The important things to remember about tenancy by the entirety is one spouse cannot unilaterally sever the tie. So one spouse can't decide to sell their interest in the property and destroy the tenancy by the entirety. Both spouses have to make that decision together, so that a bank can only foreclose if both parties sign loan documents. Some states allow banks to foreclose on one half the interest of the debtor spouse. But again, it's always best, especially if you're taking out securing the property as a loan, just to get both spouses to sign it. Both must execute a sales agreement to sell the property, and the easiest way probably to terminate a tenancy by the entirety is through divorce, and then both parties will become tenants in common with each other. So looking back earlier at my early example with Stacy and Sarah being tenants in common, as tenants in common, they're each going to have the ability to pass that interest in Blackacre on through their respective estate plans, which is very important if neither of them are related. They've just gone into business together, and they want their interest to go to their respective heirs. So they both may have children that they want the land to go to, or some other family member. But what if Stacy and Sarah are related, their mother, daughter? It's a good example. Well, you could potentially turn the tenancy in common into a joint tenancy, especially if the mother wants the daughter to get her portion of Blackacre on her death. That's one way to transfer that interest outside the will. It's, like I've said before, it's an easier way to transfer property. But then the question becomes, what happens if the daughter predeceases the mom? So now mom has another decision to make. Hopefully she has an estate plan and she is able to figure out how that property would be passed on, because that is also a possibility that could happen. So various forms of property tithing will have impacts on your estate planning. The easiest one is going to be, do you own it on your own? Is it in fee simple? If it's in fee simple, it's going to be an easy issue to deal with, more than likely, because you're going to be able to set up in your will how that piece of property is going to be inherited on your death. You may at that point decide that, for whatever reasons, you want to put in some sort of joint tenancy. You may get married and want to redo it into a tenancy by the entirety, so it goes to the surviving spouse. Or it could be a later in life situation. You remarry, both of you have kids. You may not want it to go into a tenancy by the entirety. You may want it to make sure that it goes to your kids and your new spouse's property goes to his family. Do you only hold a life estate? This is possible, that you may have property that's only held in a life estate, and if that's the case, it's fairly simple to handle that estate planning issue because it's not going to be a part of your estate plan. It's already been dealt with in someone else's estate plan, and they've already decided who the remainder man is going to be and who subsequent remainder men will be if the original remainder man is not alive. And then finally, do you own that property as a co-owner? And does the co-ownership provide some form of rights of survivorship? And if it does, and you make it to the end, are you that last surviving owner and now own it in fee simple, and now you have to think through the process of how you're going to incorporate this property into your estate plan? So one of the big issues, especially with rights of survivorship, is if you are that last surviving owner, then you have to figure out, okay, how do I work this into my estate plan? How do I make it fit my goals and how I want my property transferred? And like I've said periodically throughout this presentation, just remember that this isn't just about real property. It can be, any form of property. It's something you're going to look at and how you title it, especially if it's a big enough piece of equipment that's being utilized in a farm. You're going to want to be able to put the right form of ownership on it in order to help with the estate planning issues. Before you talk with your attorney, you'd want to go and look at how all this property is titled. That's going to be one of the first questions your estate planning attorney is going to ask you. It will help your attorney understand how to develop your estate plan based on your goals. We're working on a checklist to help make sure you have all the documents together so you can sort of make sure that before you go in, you've reviewed all your land deeds, property, personal property, ownership documents to say, okay, this is how I own this piece of property. These are my goals. This is who I want to get it. And your estate planning attorney can help you.
Thank you for watching our archived presentation of our Wednesday webinar. If you would like to see more archived Wednesday webinars, please visit our YouTube channel. Or to find a schedule of upcoming live webinars, visit our website.